how divorce orders should in fact be dealt with in pension funds are absolutely essential for a sensible outcome on the two-pot divorce, for fairness between divorcing parties, for them to get what they expect to get. So we certainly do need some sort of amendment, but the amendments won't work if they are subject to the Divorce Act that simply overrides them. So somehow the Pension Funds Act amendment have to override the Divorce Act. It's difficult, but somehow it has to be achieved. Have to override a serious problem on the divorce, because the way the law works is that the Divorce Act will govern divorcing parties, and the Pensions Fund Act will govern pension funds, and you've got both sides having completely different provisions, and that will be enormously problematic. So how it's to be resolved, we need to really put our heads together and work that out. Hopefully, a line in the Pensions Fund Act overriding the Divorce Act will work. I think that is the question that was actually asked. I'm not sure whether the details of other amendments that are not required for the two-pot system are required.
I think so. That was part of the question.
Okay. We have in the written document that was submitted to this committee, we have listed various amendments that we believe are not required for the purposes of the two-pot system, and they should wait for another day, for another process. One of those, as we said in our slide, changes a provision. At the moment, the way that you divide up what is in the fund for divorce payments is that you look at the capital that is sitting in the fund to the credit of the member. Now what has been introduced is a provision that says you can also look at the income. Now that needs extensive discussion and consideration. We really have to think about that. If all a pensioner is getting is a monthly payment out of the fund, and if the divorce order can be used to take that every month, then what exactly does the pensioner, him or herself, live on? These considerations really have to be considered. They shouldn't be put into a bill, the main intention of which is to introduce the two-pot system. There's never been a provision in the Pensions Fund Act where pension income is shared on divorce. It's not necessary to put it in now, and lots of things have to be considered in that regard. There's no provision for taxation of that. Pensions are provided outside of funds. Why should they be treated differently? There's a lot of discussion around this, and this is not the time. Also, the other item raised in the slides is the matter of, for some reason, the divorce order, where there is a divorce order, is to be sent not anymore by the interested party, being the spouse who got the order. They're not the one who must send it through to the pension fund. The registrar of the court must send it to the pension fund. Well, why? We don't know of any issues with the current setup, so why change this? It's not necessary. And this type of thing just clouds the issues of getting the basics right for the introduction of two-pot. It introduces additional concerns, misunderstandings, changing of systems unnecessarily at this particular point in time, when all we want is to get the two-pot amendments right. We just want to get the two-pot system in. So I think those are the important issues we'd like to highlight.
Thank you.
Asisa, are you done?
Yes, Chair. Thank you very much.
Okay. Let's go to IRFA. You will come after Honorable Moin. Let's allow the stakeholders to respond first.
Thanks, Honourable Chair. I will ask Nancy to respond on behalf of IRFA.
Thank you, Chair. I think that we must acknowledge that over the years, paying pension interest from a retirement fund has always been problematic in terms of determining the value of it. I think that we must acknowledge that Treasury has actually looked for the most suitable wording that kind of would apply to all retirement funds, whether it be occupational funds or retail funds, the same wording would apply. What we saw yesterday when the bill was actually the changes for the government employees pension funds and the Transnet pension funds bill, we saw a one-liner put into that bill that talks of the application of the Act. And it says, in the event of a conflict between the provisions of this Act and the Divorce Act, the provisions of the Divorce Act will prevail. Obviously, we haven't unpacked that issue, and we haven't, because we've only seen it last night. And we need to look at what the impact of that wording would be and whether it would be strong enough to actually override what is in the Divorce Act. I think that there has been a move forward in terms of trying to help retirement funds clearly determine what the pension interest would be by adding in the new definition. And yes, the first prize would be to actually have the definitions in the Divorce Act actually removed or deleted to actually make this the superseding provision. But like Asisa said, I mean, there's no time to do that. And whether this one-liner that has been put into the other pieces of draft legislation, whether that could be included into the Pension Funds Amendment Bill is what we need to analyze and see whether it would work. On the face of it, it looks like it will work, but we're always going to have to deal with challenges of divorce practice, attorneys practicing divorce, and look at how they will look at it. So I think that once it's in, we would be having seen what they've put in in the new draft public sector bills. I think it's time for us to go back and see whether that actually works for the Pension Funds Amendment Bill and have the necessary discussions with National Treasury on our views on whether this would be a workable solution or not. But again, we're not. But we support these divorce provisions and the clear definition that National Treasury has put into as recommended in the Pension Funds Amendment Bill. We support what Asisa's actually brought up about divorce payment for pensioners and the misalignment between an in-fund pensioner and a person that's purchased an annuity outside of the fund in the insurer space. And we agree that those provisions should be actually removed from the bill and opened up for discussion and more consultation before it's added back, before it becomes an effective provision. Thank you, Chair.
Thanks. Comrade Matthew, do you want to say something about this subject?
No, thanks, Chair. I think only just to, appreciate that we do have consensus on the issue. I think, Chair, the points raised by Sifa IRFA, the important and valuable points, I think, as Honorable Manyi and Honorable Masualle, other colleagues raised. So I think our only suggestion is that what needs to be done now, let's urgently fix it. Let's not delay matters. So I think those colleagues can assist Treasury, and I think Advocate Jenkins is here, so I think the legal fundis can just fix what needs to be fixed now. We can always make it more beautiful and pretty with the TLABs in August, but I think the main thing is let's get done now. So we just ensure that the 1st of September deadline is retained. And I think lastly, Chair, of course, the point that we had emphasized about ensuring that the GPF, Eskom, telecommunication pension funds, possibly Transnet, are also included. And I know this will be an important issue for Honorable Masualle, Chair, who was once in a previous life a leader of the telecommunication workers. So we would want to ensure that his constituency is included as well, Chair. Thanks, Chair and members.
Thanks, Comrade Matthew. Advocate Jenkins, can you come in, or if there's somebody from Treasury in the legal division can also come in, as much as Treasury will be responding is it next week, but for today's discussion you can also come in. Advocate Jenkins, and then Chris.
Thank you, Honourable Chairperson. Good morning to the honourable members and to colleagues and the guests. Chairperson, it is a bit of a challenge. The rule in legislation, when we interpret legislation, or I want to say when courts will interpret legislation, is that the latter statute will prevail over the previous one in places where there's irreconcilable differences, of course. So what we're having here with the Divorce Act saying that it will override also future legislation. Clearly the intent would be that the divorce proceedings will override other changes that will come even after that act. A court will then have to weigh it up against this piece of legislation that says the same, and we've become a little bit prevalent, Chair. I don't know of any examples of how it is treated in a court. My gut feeling, Chair, would be the following, and if I want to say this pursuant to finding a solution, Chair. I think what must be critical in the minds of the committee, myself, that will help with the drafting, as well as National Treasury and those who are making submissions, is that the divorce proceeding can be quite acrimonious. In my experience, it's usually acrimonious. So you will pull out all the stops, and if there's money involved, you will try and pull out all the stops. So we have these competing pieces of legislation. It's not going to be a comfortable battle, and you might get courts having contradictory statements. So I think the first prize, Chair, is to resolve it properly. Now, we've heard that the time is not on our side on that one, Chair, which is a challenge. For now, Chair, I don't have the solution right at hand. Clearly, the easiest would be to say that this provision prevails over the Divorce Act, to make it very specific and not just a general prevailing provision, because that will be two prevailing provisions basically contradicting each other. So we will have to have a specific one dealing with the Divorce Act, if that is the intention of Parliament, to have this prevail over the Divorce Act. But Chair, the most important thing I think here when we're drafting legislation is to make it really consistent with what is out there and to not sow confusion. And I think unfortunately with the speed and with the subject here, with the change, things have somehow gotten a bit of frayed at the edges, for lack of a better saying, Chair. So we need to resolve this. I think there's a deadline looming, and Chair, I'd actually say we need to resolve it regardless of the deadline, Chair, because we can't have legislation coming out that's going to confuse the courts. So it's very important that we get this right, Chair, and I think it would be to say that the Divorce Act must be subservient to this two-part system. Chair, while I'm saying that, and that's why just that we must be very sure that when we do that, it's fair and just to both parties going through a divorce, and we need to model all those areas. And Chair, that would require some work from the staff as well as from the committee, Chair. But let me leave it at that, Chair. But that's I think the easiest way at this point to challenge to face the challenge. Thank you.
Thank you, Advocate Jenkins. Chris.
Good morning, Honourable Chair, Honourable members. Thanks very much for having us. Thank you to the commentators as well for all the comments on the legislation. I'll try and go through just a couple of them to provide some feedback on our initial views. From Cosatu on including the GPF, Transnet, Post Office, yes, that we are still going ahead with that. We published a media statement yesterday. Honourable members and Chair, there are additions to the Pension Funds Amendment Bill that we also published yesterday that we would really like to include in this bill, to include the GPF, Transnet and Post Office. We hope that those will then make sure that all the public sector members are included in the two-part system from 1 September. So those are available on the website from yesterday. On the other questions on the actual legislation, my colleagues are here, Normalizo and Nhlanhla are here that can try and provide some initial insight. But just to give our commitment that we're very happy to work with the commentators on trying to get this right. As Advocate Jenkins said, we do need to get it right, and we will work with them to do what we can to make sure that it is correct and there is as little uncertainty as possible before they are promulgated, which will require obviously some small changes in the Act as well, in the bill as well. So we will work on those. Colleagues, do you want to come in to try and add to what I've said? Thanks.
If I may come in, Chair. My name is Normalizo Bulithile from Legislation, National Treasury. Good morning and good morning to the members and everybody on the platform. We are working on the bill.
The media is requesting that they want to see our faces unless there is a reason. If there is a reason, we are not obliged to show our faces. It's a request.
Okay, Chair.
Okay.
I am trying to work on that. Thank you, Chair. So what happened is that we are working with the amendments, and we welcome these changes, which we will look into. But I just want to talk in respect of the divorce. What we did, we are mindful of this change, and to the extent that it may contradict the Divorce Act, or rather the Divorce Act will supersede it. So what we did when we were drafting the amendments to the public sector pension laws, we came up with the application clause, which we have inserted, which will then trump the Divorce Act. But we can continue to talk about this. But I do understand that members do not see that provision in the public, in the Pension Funds Amendment Bill. And for us at this stage, we believe the bill is the committee bill, and we would propose as National Treasury an inclusion of that similar application clause at this committee stage for amendment, for inclusion to this bill, and it will be contained in our response. So we do intend to add that application clause that you would see in the other pension fund, or rather public sector pension fund bills or other amendments that we have prepared. Thank you, Chair.
Thanks. Are you done, Treasury?
Yes, thank you, Chair. And Nhlanhla, anything you'd like to add or not? Oh, maybe he's gone. No, that's fine, Chair. I think we are done.
Okay. Advocate Jenkins, since Treasury says there are amendments that they will want to bring to the committee, is it not allowed that before we go to clause by clause or a Treasury response, those bills will be submitted to the committee so that we don't take the public by surprise by bringing amendments towards the end? So that I think in terms of the process between now and the time Treasury responds, or when we deal with clause by clause, the public can still be allowed to make submissions so that we don't close out public participations by becoming too technical. Yeah, so I hear Normalizo talking about a clause which they will want to submit to the committee, which was not there. So that we don't submit a bill in Parliament, which will have lots of questions and lots of gaps and so on and so on. What do you suggest that they should do to bring all the stuff that they are working on before we go to clause by clause? My interest is that we should not close the public out in whatever Treasury and ourselves are doing.
Honorable Chairperson, you're saying it correctly. After the public hearings, of course, Treasury will respond to a matrix setting out the public comments and then responses or the possible responses to those comments. And then if there's a requirement or a need to amend something in the bill or add some clauses to the bill, Treasury will propose that. Now, Chair, during that stage, of course, the public is able to comment on the new changes, either because you allow them during the committee meeting to voice their issues, or they can do it, of course, in writing to the committee secretary, and that's the usual process we follow, Chair. Now, Chair, once the committee has familiarized itself with the bill, the problems with the bill, what the public thinks of the bill, of course, the next step is the motion of desirability. In other words, that the committee resolve that we're going to continue with this legislation. So that could even happen before Treasury brings in the proposals, but it's really for the committee to decide. The committee, according to the National Assembly rules, is in control of its own procedures and processes. So sooner or later, Chair, the motion of desirability must be taken. And I've always advised that it should be after public hearings, even after what the National Treasury respond, because that's when the committee really understands whether this bill should go forward as it is with the amendments or whether we can't go forward with it. So, Chair, it's then during that and deliberation sort of on the main themes, the problems that the bill might have and the solutions that are offered, that the public still has an opportunity to influence what is taken. And it's only after that, Chair, when we close to the process of having drafted amendments, that we do the clause by clause. And it's at that stage where we want to say it's either we accept the clauses or not. So, Chair, yes, you are right. There's still ample opportunity for the public to comment on this solutions Treasury will offer to the committee, as well as what the committee is prepared to accept. And of course, that the public can influence all of those, and that's all before the clause by clause process, Chairperson. I hope I've clarified that. Thank you.
Yeah, thanks, Advocate Jenkins. I think let's request Treasury to submit the clauses that they will want to see them in the bill before we go into the process whereby Treasury responds and then we go to clause by clause. So between now and by the time Treasury responds, I think we'll have received all those clauses. And they be published in whatever way, whether in the website of Parliament and or Treasury. So let's not do anything behind the veil of secrecy. Whatever is suggested by Treasury and the committee, let it be known by the public. Because on the day that Treasury is going to respond, stakeholders are also going to be allowed to ask questions and or make comments. So let's take that route. The sooner you do that, Treasury, the better. As of yesterday, if you can send the committee those amendments or those clauses that you want to see added in the bill, the better. Honorable Manyu, back to you. Follow-up question.
Yeah, thank you, Chairperson. No, Chairperson, I think I'm largely covered by Advocate Jenkins. I think he's alive to the issues and the essence and everything. My suggestion here as a non-lawyer must underline that is that I think 2 words can actually solve the problem. But before those 2 words, I think let's all be clear that the formulation of the trumping provision is not actually regulated, as it were. You can put it in such a way that it solves the problem. There are two words that can deal with this thing in the formulation of the trumping provision. The one of these words is from that date of promulgation. And I think Advocate Johnson is alive to this. He made reference to this. So the latest date usually deals with this thing. But over and above that, you can also have another word, notwithstanding, so that in the event that you have this Divorce Act that is preempting any future legislation, we also cover that with the word notwithstanding. So I think there is a careful formulation, because this is a special provision of a trumping clause here that deals with financial issues, as it were. So it can be a generic standard trumping provision. It's got to be a carefully worded that deals with these things decisively. So I think, for me, I actually don't see a crisis, Chairperson. I actually think that this thing can be formulated and can iron out these things. That's the first thing. Then the second thing, I think the nitty-gritty that IRFA was raising, I think a lot of that, as long as the legislation enables it, the nitty-gritty can be dealt with at the regulation stage. So when we do the regulations, then we can go to all the crannies and dot the I's, cross the T's, and all of that subject to an enabling legislation. I think what we are doing today is finalize all the enabling mechanisms, but those fine-tunes can really be dealt with at regulation level. We don't have to delay this act because we don't have those things. Those can be resolved at the regulation stage. Thank you, Chair. That's the only contribution. Thank you.
Thanks, Honorable Moyi. I think, okay, I see somebody from National Treasury. Who is that? Tandizile Alvina Teller. Over to you.
Thank you, Chair. Good morning. I just want to clarify the process outlined by Advocate Jenkins. Treasury has already sent through the proposed amendments to the public sector laws to the committee. We sent them yesterday. So I just want to clarify, is the committee going to release those for public consultation? We've also made them available on the Treasury website, but we have not called for public comments. We've just put them on the website and then subsequently sent them through to the committee. So are we, is Parliament going to, sorry, the committee going to request comments on those and will respond to those public sector laws amendments when we respond on the PFA bill as well? Just clarity there. Thank you.
Okay, thanks. We'll process them. Committee Secretariat announcements. By the way, when is Treasury coming to respond? Is it next week, Tuesday?
Yes, Chairperson, on the 19th.
Yes, sir. Yeah.
19th. Okay. So let's make sure that let's deal with all the outstanding issues between now and the 19th. Attend to all those proposed clauses by Treasury. Publish them in all the platforms so that the public is able to make submissions or make comments, and also for them to come ready for engagement with the committee and Treasury on the 19th. Any other announcement?
The committee will be meeting again tomorrow. On the...
By the way, tomorrow processing Dr. George's bill.
Yes, sir.
Okay. Okay, thanks very much, honorable members, stakeholders, and support team, and the media. Let's adjourn this meeting, and we meet again tomorrow. Same time, same platform. Thanks very much.
Long live the chair.
Recording stopped.